Okay, we can start recording a little early.
We are now recording.
Okay, thanks, Maddie. As soon as the atomic clock says 1. All right, the atomic clock says 1 o'clock. So it is Wednesday, October 15th, 2025, and this is a meeting of the Land Use Review Board. I am Janet Hurley, the chair, and I will ask board members to introduce themselves. Alex.
Alex Weinhagen, board member. Hello.
Sarah.
Sarah Had, board member. Hello.
Brooke.
Brooke Dingledine. Good afternoon.
And Kirsten.
Kirsten Sultan.
Okay, we are all present, all 5 of us. Are there any updates to the agenda? Sarah.
For item E, under attorney-client communications and executive session, I'd also like to add personnel, or the discussion on personnel, no action.
I'll second.
Okay, thank you. Any discussion on that before we vote? Okay, all those in favor, please say aye. Aye.
Aye.
Aye.
All right, our executive session will include personnel matters. We just have a quick update on budgetary submission and response. So maybe we can add that after opportunity for public comments. It should be, it's just an announcement, really, so.
Sounds good.
Okay, can I get a motion to add that?
So moved.
Thank
I'll
you.
second.
Thank you. All those in favor, please say aye. Aye.
Aye.
Aye.
Aye.
Okay, thank you. So before appeals, we'll just very briefly touch on our budget submission. Okay, opportunity for public comments. Thomas, do you have anything for us today?
You were muted, so you might need to try again.
No, I have nothing today. I'm
Okay.
under this section.
Okay, thanks. All right, so Rachel, do you want to give just a brief description of what we got back from Finance and Management on our budget submission?
Yeah. Sure. So yesterday we submitted the FY27 budget and FY26 budget adjustment proposals and supplemental materials and narratives to the governor's office, the Agency of Administration and Finance and Management. Yesterday was the submission deadline. We got a very quick reply from Finance and Management, kind of flagging that they may require us to provide itemized reductions to meet the 3% general fund targeted increase. So yesterday, I asked for more clarification from Finance and Management, given some of the background information about why we requested over a 3% general fund increase. As you recall, that was tied to, 2 positions that were created last session and were only partially funded during that time period. It's the reason why we have over a 3% general fund increase in our proposal this year. So noted that for Finance and Management to contemplate, and we are waiting to get more instructions, but we wanted to flag that with you, that this may be a topic that we have to discuss at future board meetings. Any questions about that or the submissions themselves?
Question, just, appreciation for that you followed up with them. I read the narrative that was submitted with the original proposal. It seemed to explain it to me, but it was brief, especially the part about the budget being beyond the 3% recommended. So thanks for following up. I guess we'll wait to hear more, and go from there.
I think
Yeah.
what they're gonna be asking us for, if indeed they do, is for us to decide as a board where we would cut. Or where we would, what line items we would change in the budget to account for only a 3% versus a 6.2%. So that's why it needs to come back to the board, and we will have to have that discussion at a board meeting. Sarah?
Can I add
Yes.
one thing to that, Janet?
Yeah,
Itemized reductions or alternate funding mechanisms. I
Yes.
think both could be tools to address this if finance and management clarifies that they do want us to address it.
yes.
Sorry, Sarah.
No, perfect. Just what I was going to inquire about.
Okay. Okay, anything further on that item? Okay, let's move on to appeals study draft report. Brooke submitted this to us yesterday. I haven't had time to read but a few pages of it at this point. But I appreciate that it's ready for us, and we will be discussing it for the next couple of board meetings. Brooke, do you want to take it away?
Sure, thank you. Let me start off by saying this is a first draft. I'm keeping track of a number of some issues that I think we need to insert and address that came up during the study, which, while we may have a 24,000 foot mention of it, requires some explaining the analysis of how we got to where we are. There are a couple of pieces and parts that I just didn't have time to get to, like we need to have a section on the Ombuds office and to actually explain about how this has become a burden on, and we're handling it and assist everyone, but this is what would be very useful across, more than just our program, or maybe we don't even go there, but we need to do more to articulate and dovetail with the wood products manufacturing report about how this could help. I think putting in a better articulation of that and more information and analysis about the evaluation that we have done about our current resources versus, while we can repurpose some of our legal staff, explaining, for example, that as an appellate attorney, that's a much different burden, and especially the firewall issue and the rules that I still have to insert. So there are a number of issues that still need to be addressed, or things that are in the report that need better development. So my hope is that at this stage, I don't need corrections to spelling necessarily. I need those bigger, like, what did I miss? What needs to be better explained? No pride of authorship. If somebody wants to work on sections and say, I'd rather have it this, for my purposes, a red line strikeout version would be most useful. And so let me go ahead and share the document. Or Janet, how would you like to proceed on this? Or how the board like to?
Let's see. I only got through page 10. How much have others gotten further? Sarah has. Alex has.
I've read it, and I don't think it would benefit us to go page by page through this
Yeah, me
document.
neither.
I prefer to
Kirsten?
just start talking about it.
Yeah, Kirsten, have you read a substantial portion of it?
I have.
Okay, so it's just me. I'm the delinquent.
Well,
Well,
maybe.
I-
Sorry, go ahead.
Sorry, I just
Well,
would
just-
add, I do want to read it again. I read it quickly because it's sort of hot off the press and I wanted
Yeah.
to come to this meeting sort of informed. And thank you, Brooke. I think it's, great job and a lot of information in there and it, captures all the different areas and topics and so, thanks. But I do want to read through it again with a keener eye and just be able to be more prepared to provide meaningful feedback. I'm not quite there.
Sarah?
So also kudos to Brooke. This was something that, as I read it through in its entirety, at least once last night, and a couple sections I had a chance to sort of go into again. It's a lot. It's really captured a lot of the board's dialogue thus far. There wasn't really anything that was foreign to it. So I would sort of agree that what I was looking forward to today is sort of a generalized discussion. And there might be some areas that we might want to discuss, reread, talk about, and come back to. But overall, nicely done at pulling it all together. It's a lot of work. And so I heard you identify some areas that you still have to get to, but kudos.
Thanks.
Alex?
Yeah, same. I want to heap on the praise. Thank you, Brooke, for pulling it together. I had very much the same impression Sarah did when I read it last night, that the recommendations, I think, pretty much are spot on to what we discussed. And so thanks for capturing, what we were trying to say through these discussions, and for getting all the detail of the process involved. It's a nice thing to read through it and see the recognition of the various participants and all that. So yeah, of course we'll edit it. Of course, we'll tune it up, maybe make some changes here and there, but this is a great start, and thank you so much for doing it. With that said, I have detailed, comments on the whole damn thing, because that's how I am. So what I was thinking of is, rather than walking down all my comments, and just hearing me blather, I thought I could give a couple of introductory remarks, and then maybe just spotlight on a few substantive things, and then send you my more mundane comments. So, and then you can decide what to do with them at your will. I don't think they'd necessarily warrant a full board discussion. So if you'll indulge me, my overall comments were that I think you sorry, go ahead.
Let me just interrupt just for a second, because since Janet hasn't had a chance to read through it, maybe if I just took like 2 minutes just to look at the structure, like the table of contents, just to explain sort of, the flow to it, just as an introductory thing, maybe, or not. I mean, everyone else, if Janet doesn't think that's necessary,
No, I mean, I read there's sort of like an executive summary right up front, and I would agree. It sounds like, though I haven't gotten through it, that it sounds like it captures the thrust of the board's discussions previously. And I also think that, through page 10, it's well written. It doesn't need a whole lot of, sort of the kind of mundane improvements that we may need to stick in here and there. But I think I wouldn't mind hearing Alex's 2 overall comments first, if that's okay, Brooke.
Oh, of course.
Okay.
Alex, do you want me to share the document or anything?
Not yet.
Okay.
So, yeah, the 2 big takeaways for me were that what I said before, that it seems like you captured the recommendations as we discussed them. The only one that I continue to want to push back on is the 3-year phase-in for the board taking over appeals potentially of Act 250 permits and jurisdictional opinions. And I think I'm in the minority, but I just want to continue to, say that I think that can happen sooner. I think that could happen on a 2-year time horizon. And the way the report is structured, the recommendation is a 3-year time horizon with a check-in after 2 years. And I might like to say a 2-year time horizon with a check-in, next year to see how we're doing. So that's a substantive, not criticism, but suggestion on a change to the recommendation. So beyond that, the only other thing I would say is that, and you'll see this when I forward you my comments, there's a lot of repetition within and between sections. I think you can shrink the pages by getting rid of some of that repetition. And so I've commented on the sections where I think that it's repetitive, so you can sort of say, oh yeah, it is, and I can take that out. And there are a couple of places where there's a lot of procedural detail, and I wondered if that might be better in an appendix in certain spots, only because the audience that we are writing this for, I don't think they're going to pay attention to that level of procedural detail in the way, for example, that the environmental division works its process, and all of the references to the specific rules, rule 1, rule 2. I don't think legislators are going to get anything out of that. And the shorter we can make it, I think the more likely they are to pay attention to what we want them to pay attention to. So yeah, those were my overarching comments. A couple of more substantive things further on I can go into, but I don't want to hog the microphone. So maybe somebody else who wants to make some comments and you come back to me.
So I presume that, I'm sorry, Brooke, that Thomas maybe has a hand up, but I'd like to hear from board members first, if that's okay, Thomas, and we'll come back to you afterward.
Well, I was hoping that we could at least go over the outline so I have some idea of what the structure of this rule is.
Sure. Let's hear from each board member that has something first, and then we can do that. Sarah?
So I think also I have some specific things, but just to sort of go to the 10,000 foot level on where I think offering comments. I think Alex had voiced his opinion about the timeline at a previous meeting. I would actually endorse what you're putting forth as a timeline, and I think was specifically on page 30, where you're discussing tier 1As and 1Bs. And I think that's an area that you could elaborate a little bit more on all the unknowns that we're facing with how many tier 1s there will be, how many permits within that, how many appeals. So in terms of one of the recommendations is to possibly take appeals from tier 1s, but we first have to figure out what these are. We're not even going to get to the first tier 1s until probably midway through 2026. And then to actually see the permits they process and the appeals that might come out of it, I think that is a valid area to look at, particularly given the possibility of specifically effectuating housing in a very positive way. But again, I think that sort of is the reason why I'm looking at that sort of longer 2 to 3 year timeline as opposed to the 1 to 2 year, because we're really not sure what we're getting into. We're offering ourselves. But in terms of being able to evaluate resources critically, we just don't know what we're getting into. Whereas a year from now, we might know a little bit more about it. And I think that is an area that's very critical to advancing housing in the state, is minimizing or expediting possible appeals within areas that have gone through those extra hoops to have a higher level of standard of review and care. So that's just sort of a 10,000 foot offering, but thanks.
Kirsten?
And so I'll just offer these sort of as preliminary comments, but I also want to, look at it again myself. So partly in response to Alex saying kind of the procedural content, maybe some of that could go in an appendix. I also found myself pausing a little bit in that section of the report, and I wondered if that area could benefit from more detail to help like a lay reader just understand what those elements mean in some places. So if you do decide to put it into an appendix, maybe some of it could actually be expanded a little bit to help, just explain some of those legal elements. And the other thing that I want to go back to, but I'll just kind of put a pin in, maybe we can touch on at our next board meeting when we discuss this, is the staffing. I feel like that's something that would be revisited at the check-in point. When we do the updated status based on volume of appeals and recommendations, to see where we are and if it is at a 2-year time frame. I think that we would be looking at that information alongside what we think the staffing would need to be. So I don't want to definitively define what we think that is now. That's just my own sort of perspective on where we are with that detail.
So before I go to Alex, Brooke, I do want to give you a chance to give that overview and maybe show the table of contents for Thomas's benefit as well as others. Alex, do you have something to say before Brooke does that would inform that?
Go ahead. I'll wait until after the overview.
Okay.
And before I put up the document, let me just, before we leave this conversation, there are just a couple things that I wanted to add. The timing is because before we would be able to be an appellate board, we would need to enact the procedural rules for appeals. And depending on, if we were told immediately, yes, we want you to do this and we'll check in with you, maybe it could conceivably be folded into the changes that we are making now for the other Act 181 procedural rule changes. However, it sounds more likely that if this were going to happen, it would need to happen after that check-in period. And so the problem about then getting up and running is the amount of time that rulemaking takes. You got to have the rule all ready to go. And then it's, I think, and Rebecca, correct me if I'm wrong, but it takes almost like 9 months or something to get through all of that process. So to me, I think that there are immovable time issues that really end up, in my mind, making the realistic time frame 3 years, Alex. That's where I came down on it. But I hear you. I understand. Now, let me get that document up. And
You want me? Oh, I got it.
okay. So this is the table of contents. It's probably the best thing to look at. And then we'll just take a quick pop into the document briefly. But we have an executive summary that gives, very obviously a 1 or 2 sentence recommendation on each of the questions. We have an introduction to explaining what this is. And then we give a legislative charge. We give the law. And then we go into a section on the background and history of Act 250, how it works, so that there is a basic understanding of how we operate, district commissions, district coordinators, etc. Then we give some background on the environmental division, and it's very brief, but they took over in 2004 or 5 when jurisdiction was moved from the environmental board. We then explain the establishment of the Land Use Review Board and what our obligations and job are. We then go into an explanation of the stakeholder meeting process and the appeals study, who was involved. And then we go back to a section on the environmental division and how the appeals are being processed. Presently, we gave data on caseload volumes, meaning how many cases are being dealt with, for example, at the district commission and the district coordinators. How many decisions are they issuing a year? And, you know, we've been fluctuating between like 350 and 400 on district commission decisions. So it's important that that overall volume is appreciated and understood, because the number of appeals are minuscule. They are less than 2% of Act 250 appeals. So we then go through, and this is the detail that both Alex and Kirsten were referring to, I believe. And I wrestled with how much detail to put in. Certainly the rule, you know, I didn't put footnotes in. I'm going to work on that to make it more readable for a lay person. But the information is really important. And this is why. We need to be able to, when I'm going to develop the explanation of our board model and how we're going to operate, in my mind, we need to be able to demonstrate that we can implement a system that has shorter time frames, that we can do this faster, like everybody says. But understanding each process within litigation is really important, because especially to make sure that we are operating on facts, not perception, there are limitations to what you can do, even under the APA, in terms of curtailing discovery and motions. We've talked about it ad nauseum. But that's why that information is in there. We can certainly work on, you know, fine tuning it, but I think it's important, almost even if you don't understand or read it too carefully. Yeah, there's a lot that goes on. That's sort of the portrayal. And when we get to our more fleshed out explanation of how we're going to operate, we can show what we're not going to do or what we're going to do very quickly within that grouping of universe of things that happen during the litigation process. And we also want to make sure that the judiciary gets their due in terms of adopting the Rule 5 rule change already, and they are really operating on more than all cylinders with their clearance rates. So I think it's really important that we make sure that an objective viewpoint is expressed with factual data. A&R, literally, it's a cut and paste of what Billy Coster has emailed me during different sections of the study. There is also a standalone document that was addressing whether or not the ALJ model was endorsed or not by A&R. And I plan to put that in as an addenda appendix. But because we got past that issue, it really wasn't relevant. However, there are some really important positions that they take in terms of they felt the confines of this study was very limited with regard to A&R permitting. So I want to be sure that they have the opportunity to have that expressed in the document as well as an appendix. We then go into the Land Use Review Board's proposed model. This is really just the information from the chart that I created in the notes. That section needs to be fully developed so that we explain here's all of these things in more than just a half a sentence notation, and this is how we're going to operate, and including staffing and all of that. So that section needs work, but I want to finish the board rules. I'm working on them in conjunction. I'm hoping to have that finished by next week. So the next thing that we do is talk about the court versus the board debate. I thought it was important to make the salient issues on both sides. They have compelling arguments. It needs some work because in many ways it's sort of like the way it's expressed is very similar. Like this board will give you better decisions, versus the court will give you better decisions. And it's almost like, what's the definition of better? Do you want the collective, process of the board with various expertise being able to implement policy versus, legal interpretation? So we did get that out to make sure everyone was heard on that. The board capacity and timing section, that needs work, obviously. And Sarah, I appreciate your comments, definitely. So any input into language or is more than welcome. And then we get to the board recommendations. I think that those require better analysis and explanation, although we sort of put it in almost like an outline kind of format to identify all the important issues or pros, cons, whatever. I would like to rewrite that in a better, more narrative format so that you can understand the complete analysis, but in a summary fashion, I think. And then we have a bunch of appendices. And then for Thomas's viewing, well, what I tried to do is make it very clear in an executive summary instead of writing paragraphs. And, everything's not perfect yet, but so that someone has a quick glance to see what these recommendations are buried at the very end of the report. And other improvements, we have a couple things still cooking in the oven on that. Anyway, that's the setup. Alex,
Great,
do you want me
thanks.
to take down the
Could you,
document?
could you stop the share? It's easier for me if I can see everybody. Okay, so I'm just gonna give you a few specific items. And like I said, I'll forward you my longer set of comments on just more mundane stuff. So you already mentioned this, so I'm just sort of agreeing with you that section 8, which is the land use review board's proposed board model, I think it reads what the specifics are fine. It needs an introductory paragraph to walk you into that section. So you talked about really wanting to polish it up, and I don't think it needs a lot of polishing. I think it just needs an introductory paragraph or two. So that was my first one. Let's see.
Before you go on, the other thing I was contemplating is like on the hybrid standard to explain about it and that it serves, the interests that it serves. I mean, that was the kind of thing, not reams and reams, but just a little bit more information about what we have chosen. So that's where I was kind of going with it.
Okay. Section 9, the court versus the board debate. Again, I'm agreeing with you. This is really an awkward section. It feels like it's us advocating for both sides of the debate. And it's awkward to only talk about the pros of each side of the debate and then have the same pros on either side, sort of looking like they're, it feels like cheerleading without analysis, without providing some perspective on what are the most important elements of each side, rather than just a laundry list of everything that everybody ever said about it. So I'm not sure what to do with that section, but it sounds like you also want to tweak it some. So, maybe focus on just what are the true pros that are different and unique on each side, rather than trying to list all of them. Just an idea.
Yeah.
In this section, it talks about public trust and transparency. So under the case for keeping appeals with the court, it talks about that the judiciary is well established and ensures transparency and public participation. And then there's a sentence that says a land use review board might not have the same level of procedural transparency or public accountability, which could erode trust in the decision-making process. Please delete that sentence. I don't want this report anywhere to imply that whatever we might do would not be publicly transparent. I think we are exceedingly that, far more than the court, frankly. that stuck in my craw, as you can tell. Let's see.
Yeah, I didn't like that, that particular language either, and, it was a red flag for me that I was debating, and then, I got off to something else and forgot to go back to it. Although, I mean, the point is more about, I think, like this, established judicial process. I agree with you. I think we are much more accessible and transparent to the public. You can go on an Act 250 database. Now, can you see all the documents that are filed in court? No, I don't. I can because I'm a lawyer, but normal people can see a docket, but they can't look at actual documents. So, point well taken. I will eliminate that, and if there's a way to express what the argument was, otherwise I'll try.
I think that to that point, that what you're trying to communicate there is because the court is established, there's some trust, some earned trust in terms of comfort level with that, and with anything new, you're going to have to earn trust. And I think a nice way of framing that is to recognize that, and also say that we have begun to try and be as transparent as possible, because we are recognizing we're the new kids on the block. We have to earn that level of trust, and we're doing it, and we're trying to exceed expectations with transparency. So I think there's a nice way of framing it while recognizing that the current system is sort of the tried and true, and perhaps has a better level of buy-in just because that's what's been there and has been working and people have familiarity with it.
Yep, and I agree, but I don't think we need to mention our board in the same breath that we mentioned the trust that the court has established. Like you can talk about the positive side of the court model without talking about our need to build that trust, or the fact that we don't have it yet, or that we're working on it. But in any case, in that same section under legal recourse and appeals, there's again, it's the last sentence that I would recommend striking. It says it is unclear whether a land use review board would offer the same level of appellate oversight, potentially limiting legal recourse for affected parties. Unless I'm mistaken, legal recourse is exactly the same. It's to appeal a decision to the Vermont Supreme Court. So unless I missed something, I don't think there's any differential between a board model and a court model with regard to the legal recourse once that first level appellate decision is reached.
Yeah, I'll clarify that. I think what they were talking about is more like law trained judges, as opposed like the actual decision makers, as opposed to like, if we're going to shut them down to some extent under an APA. But point well taken. I will address that as well.
Okay. Let's see. There were just one or two others. So I think I'm maybe echoing a comment that's already been made, but in the section on, let's see, it's section 11, board recommendations, and it talks about the cost benefit analysis, which I think is important. And you've swayed me, Brooke, with our conversations about, cost effectiveness, given that we're only going to potentially be taking 10% of the environmental court's work caseload. But I'm not comfortable with the numbers that are in there. I wasn't when we talked about them last time. I'm still not comfortable. I don't think $395,000 annually is the right number. I don't think that we need to factor in hiring another attorney. I think we should be. I think there should be a recognition that there will be increased ongoing costs. And we could even put a ballpark number in there, but I would feel more comfortable if that ballpark number was a full-time legal technician and whatever carrying costs for, database management and the like. But I don't think, especially if we're going to wait 3 years, 3 years from now, we should be done with, the bulk of the 181 work. We should have updated our general rules. We should have those procedures for having an appellate function. Our new attorney should be able to be leveraged without having to hire a fourth one. That's just my opinion. I understand other board members may disagree, but that was my comment on that section. And then let's
And
see.
Alex, that's part of the 3-year time horizon, because if we are gonna repurpose our Act 181 lawyer, we gotta get through the bulk of that. So
Sure. So
totally,
I still
totally
think
appreciate it.
I still think a 2-year time horizon makes sense, but I know I'm in the minority, but I don't want us to have it both ways. We can't say we can't do it for 3 years and we need to be budgeted $400,000 per year extra so we can hire another attorney. That doesn't work for me.
So let me ask this, in terms of the proposal for resources, I think there is a need to see if we can, present, this is how we're going to utilize our personnel. We expect, the 1.5 lawyer, whatever it ends up being, that would be able to address, be an appellate lawyer, take on a different role. And so the question that I have is, do we say, to take on just Act 250? We think we can do this with existing personnel. However, we need more space in our database, or there still will be those upfront costs. So I think I need a little bit more guidance and direction if we want to be more specific about it, to say, you know what? The first thing we could do is take on Act 250 appeals. We know what the universe of those is, absent whatever's going to happen in the future. But we think that we could handle that once the Act 181 jobs are primarily finished. And we can do it with our existing personnel, we believe. And this is how we do it. If then with the check-in and what happens with tier zoning, if you would like us to take on that, that's when we truly need another person for legal support, perhaps depending on what the volumes are. But do we want to present the notion that we think it's possible to stay in the number of employees that we have and be able to do the appellate function, or not?
So again, I think that we need another legal technician. I don't think it's possible with our current staffing. I do think we need more staffing, but I think it's one full-time legal technician, and I'd like the number to reflect that.
Okay.
As for the potential increase, and I'm just one board member, of course, Brooke, but as for the potential increase from other tiers coming in, that increase will accrue to whatever the appellate body is at the time, right? So it's either the court's going to need more resources to deal with this explosion of appeals, or we are. And I don't think we need to worry about that in this report. I think we could mention that, that's a possibility, but I don't think we need to hedge or sort of tiptoe around that. I think if there's an explosion in appeals due to the tiers, the legislature is going to need to apply more resources in whatever fashion to whichever body is doing it. So I'm more concerned about the initial ramp up, which I think again is a legal technician to me, which is not $395,000, I don't believe. So just one more thing, and then I'll let the mic go. So in this same section, but a little later on page 31, it's recommendation number 6, other actions to promote the efficient and effective adjudication of appeals. And one of those is 1B is training for district commissioners. And one of the sentences says, this training will enhance the consistency and quality of decisions at the district level, reducing the likelihood of appeals and improving overall consistency and efficiency. This is not a topic I remember us discussing. So I think you nailed it everywhere, but this one I must have missed. I'm concerned that this is sending the message that right now our district commissions are sort of all over the map, that there is no consistency and that it's an inefficient system. And I don't think that's the case. And I don't want to send that message. Obviously, we could always make our systems better. And I think part of the point of having this board is to do that. I don't think that it's really important on the appeal side of the equation. But I just want to be careful because I think this is mentioned in the executive summary as well. It's called out. So people are going to see that. And I think they're going to get the wrong impression that this board has some sort of concern or lack of trust or in our district commissions, which I don't think we do. So I would love it if that language could be tempered or removed.
Gotcha.
Okay, Sarah.
If we do it right, there's not going to be an explosion of appeals under the tiers. I just want to address that first and foremost. I think that was not well put. I think that the broader issue is if we do this right, there will be reduced appeals. And then there's additional cost no matter which way you slice it with taking on appeals. And I think just on a cost benefit analysis, a couple of years from now, you could have one where with even a smaller increased cost, but a decrease in appeals, the cost benefit ratio on taking over any of these appeals might be vastly different than the one that we're looking at right now. It might actually be more costly to take on appeals because there are fewer of them. Wouldn't that be great? But I worry about, and here's where I think we have to thread things very carefully, is in producing the report, somebody could latch onto it and say, oh, the cost of them taking this on is X. And is it X now? It's X plus Y now. It's going to be X at a point in the future. And so I think we need to offer the costs that we estimate for right now versus the cost in 3 years, because these are recommendations. It's not up to us to decide. And there might be those in that decision-making capability that want to do it now. I think that's part of what we've been charged with. So I think we have to be very careful in how we present the findings here. And so I do think sort of as I understand what Alex is asking for, I think there's ability to address that, but I also think that we need to keep in that number for what it would cost to do that now. And I don't think that we need to go into the missed opportunity cost, because I think if we take on appeals now, we miss some of the opportunities to address some of the rules and guidance in the cleanup, because we'd be taking our focus and moving it to the appeal sooner. But I think just in terms of hard cost, in terms of if we were to do that right now with everything else that we have going, we would need an extra attorney. We would need a legal technician. If we can wait, we can reprioritize ourselves. And so I think that's maybe worth a little bit more discussion there. But I also just want to be very careful with, if we do our jobs right, there will not be an explosion of appeals under tier 1. I think what we're charged with and what we're doing here and what we're doing in our work is actually trying to decrease the uncertainty, increase clarity, and hopefully limit appeals and time spent with appeals and the number of appeals.
Sarah, I hear what you're saying. I think one thing I would say is I do not want to give the impression that this board could take appeals now. There's no way that we can take appeals before the end of 2026. We have way too much in the air that we need to get through before we take appeals. And we do need to do the APA rule making. And that's not going to be started until 2027. So I hear what you're saying, but I don't want to give the impression that we think that we could do this if we had another lawyer right now and another technician, because we cannot.
Agreed.
In my opinion. So,
agreed.
So careful about how we present that cost determination.
Which also means, Brooke, I think it's important to use maybe some dates rather than just 2 years, 3 years. Nobody's going to know when the clock started on a 2-year or 3-year time horizon. So, if I'm advocating July 1, 2027. I know I'm in the minority. Everyone else is in 2028 as the 3-year clock, I think. Maybe it would be good to use the date that we mean in the report rather than the 3-year terminology.
Yeah, and I think if we give more specifics about the timeline of the tasks that we actually have to do, we're we're already receiving regional plans. This is the time horizon for that process will not be completed until. I think giving some more specifics, not, I don't have to get too in the mud on and muddy details on it, but I do think it's important to demonstrate, not just say, oh, we got a lot of tasks to do, to actually explain the capacity, and why it's 2 years for the check-in, if that's what we choose to do, where the rulemaking is going to be, for example, at that moment. Yeah, so, but
So
I do agree
you're
with you,
talking about,
Janet. I don't think
yeah,
that it's like, what's the point of saying we could do it if we had, well, we can't do it, even if we had lawyers right now.
right. So just being careful about how it's presented, but you're talking about your section 10 and fleshing that out, board consideration and timing. Board capacity and timing
Capacity.
considerations, which right now is just a paragraph, but maybe deserves to be a page.
Yeah.
Yeah.
Sure. Kirsten?
So Brooke, quite some time ago, I had offered and started to draw up a chart of the timeline of the board's work. And then some of those work tasks were becoming moving targets, and it was a little hard to definitively make, represent what that is. But maybe that would be something that would be good for me to get to a finish line, and include as an exhibit to help, convey that information, at least at a point in time, and as a component of this report, and explain it more definitively. And I also had a similar thought to Alex as to the check-in. I think it will be helpful to have some definitive dates, like what is 2 years, what is 3 years, and also, as importantly, I think we should say what exactly will be in that check-in. Like, we don't want to go through all this again, right? We're not going to like reinvent
Right.
this whole lengthy process that you've been through with a large number of stakeholders, but it needs to be sort of brought up to date with any newer information about the numbers of appeals, that kind of thing, I was thinking. So I would try to be more explicit, or, I think it would be helpful to the legislature when they receive this. And I would think at the 2 year mark would be, we would provide that 2 year check-in at the beginning of the legislative session, like, roughly 2 years from the date that it's submitted, which
So
is, middle of next month. Yeah,
Define the items that we're going to check in with them about.
yeah,
Once
just so it's
Yeah,
clear.
yeah, okay.
So it doesn't take on a life of its own. And I generally agree with what Alex was saying about the staffing. But even that, like, and as I said already earlier in this meeting, I think that check-in would encompass, taking a look at staffing as a component of an updated recommendation, and including the tech position. Like, I think it should just be, I don't think we need to be really definitive about that component now. But
Right.
that's just my.
And I would say, to add to that check-in, that we do have another task, another charge, legislative charge, and that is to develop a community engagement plan, and that needs to be ready by July 1, 2027, I think, if I'm remembering correctly. But that will be something that is then on this board's plate, in addition to rolling applications from regional planning commissions. And we don't know, and municipalities that may want tier 1, and we don't yet know what kind of, how much, what kind of volume we're going to have in that case. So those are two things to consider at that check-in point.
Yep. And
Alex,
the,
oops, sorry.
Janet, the timeline that you did about showing us the succession of regional planning, that's really useful and helpful. I just didn't have time to like turn that into any paragraphs or
could-
pages.
Well, it could go in an appendix, you know, and
Yeah, that would be good.
there may need to be a couple of tweaks to it, but it could go in an appendix. And I don't know if Sarah might be able to come up with a similar schematic showing expected tier 1A applications. But yeah, maybe that could be appendicized instead of, we can just
Yeah.
say, we will be taking in regional plan applications through 2026, and at times we'll be reviewing 6 plans at once, and that kind of thing. So, yeah,
Right.
Yeah,
Alex.
the one.
Oh, sorry.
Sorry. The one that I had started was really focused on the Act 181 studies and reports and rulemaking, and did not depict the regional plan and tier 1A applications in the way that you've compiled, which I think that's the kind of visual that's just helpful. So, Brooke, if you want, I'd be happy to get that to a finish line based on what we know now.
Oh, that'd be great. I don't know if we can have one timeline for everything. There may be too much on it.
Yeah.
Oh, we can.
Alex.
So pretend I'm a legislator who wants to act on this. And I get this report and it tells me that the board is recommending that appeals of at least Act 250 permits come to the board. And I'm a legislator who's like, okay, I'm going to draft a bill to make that happen. But then I read that it's 3 years out and there's a check-in process in 2 years. How do I write that bill? Or are we basically telling the legislature, don't write the bill? Wait until next year or 2 years from now to write the bill. Put this report on a shelf and try to remember it 2 years from now and take action then. Is that what we're basically recommending? Or are we recommending that they write legislation, pass it, and that the phase-in, happens 3 years hence, and only after we say okay after a 2-year check-in? What are your thoughts on that?
I think that is what we are asking, that we're not asking them to write something this second half of this biennial. We're asking them to give us a little bit of time to get some things done, and maybe next year to start thinking about how to put together that legislation.
Maybe we should say that, and then in those clear words for,
Yeah.
the average lay person / legislator to understand, which is we recommend no action at this time, and rather that the legislature take this up during this session, whatever that session is. I guess it would be the 2020, either the 2027 or the 2028 session, something like that, probably 2027, I guess. But that might be easier for them to understand what we're actually recommending.
Yeah,
Just a thought.
I mean, I think in my mind, it's like there are good reasons that what we're acting on to take Act 250 appeals. And we think it's a good idea, and we're recommending that they give us Act 250 appeals. But we are too busy right now to be able to do that. So I would prefer, I think, Alex, this is a really important point. I think if the board's position is we will take them, we believe that we can do it with existing resources, except for this. We need some money to fix the database, and we need a tech person if we're going to take on those appeals or not. That's the piece that needs to be decided, I think, if we're going to do it. Assuming that volumes remain the same, we believe, if it's what we believe, that we can, when we're done with Act 181 or almost done with it, then we can become the appellate board for Act 181, for Act 250. And then we will also check in with you about our capacity to take on zoning, help with the housing crisis, etc. That to me is like, sure, we can offer to do it, but we have no information really to say, sure, this is a good idea. What if there are too many of them or not? You know, there's so many unknowns. But the one thing that we do know is that Act 250 appeals have stayed pretty darn static over the years. There are a small number of them, but we think it's important for us to be the appellate board for many of the reasons we've all talked about: policy, implementation, yada, yada. So do we want to say, we will do Act 250? I mean, you could write a law now that says, we'll check in with you in 2 years, but we're going to do it on the 3rd year and we'll talk about the tiers. Or do they just wait around for 2 years, have the check-in and then do something? I don't know enough about the legislature. But I think we need to figure out what we are. Alex is right. It's like, what am I telling the legislature we're going to do or not? If it's we're not sure, check in with us in 2 years. That's different than, yes, we want to take Act 250, we can do it. And these are the resources we need, assuming nothing changes.
Yeah, that's part of why I was asking the questions, because the check-in thing was confusing to me, and I wasn't sure if the intention was to say, we see the advantages, but we're not really sure yet. So check in with us in 2 years and then we'll tell you whether we can really do it. Or if it was, nope, we think it's good, let's do it, but we need to put it out for 3 years. PS, check in with us at 2. We might ask for more money or something like that. Yeah.
And, you know, they don't want an answer in 2 years. They want an answer now, which is what they're asking for in this study. So I'm going to suggest that we say we can take Act 250. We need a tech and some money to be able to take the documents and have space for them. But we can't do it until 3 years from now. And in
3 years
2
from now
years
is
we-
20, so are you thinking July 1, 2028?
yeah. Right. And we'll tell you what's going on at the 2-year mark so that you can assess whether to also transfer housing, any of the, or Tier 1A and Tier 1B housing to help with the housing prices.
So that's where I would differ with you, Brooke. I like what you said, the general approach. I think that's what our recommendation should be. It's clearer that way. But where I would differ is, I think the report makes a good case for why we should take Tier 1A and 1B appeals and allow for consolidation on any appeal at, from the municipal level. I'm prepared to say we can do all of that in 3 years with additional resources like the legal tech and the database money. And that the only thing we want to do at the 2-year mark is just be able to check in regarding, our budgetary assumptions and talk to them about that. But that if they want to write a law this session that says in 3 years, the LURB takes over Act 250 appeals and those others, municipal that we mentioned, I'm happy doing that. I think that's what the report indicates, really.
I'm good with that too, but I want to make sure. So at 2 years, we're basically checking in to tell them, now that we know more information, these are the resources that are required, either to confirm what we told them or to say, oh my gosh, it's very different than we assumed. Does that sound? Or do we not want to check in? Do we just want to say in 3 years we can do it? Alex, 3 years is going to end up being 2.5. Already.
It's like our terms. It's all consistent with our terms as well. So the danger in this approach is that if we say, go write the bill right now and give it to us in 3 years, but we say we need more money, but hey, we don't need that money for 3 years. They don't budget 3 years ahead, as far as I know. And so there's the potential downside for us that we could accept a responsibility and never get the funding we need to actually do it. And that might speak to, us making a calculation in our recommendation that, like, nope, maybe you wait to write this bill until you can sync it up with the budgetary conversation, because without the funding, we can't do it even in 3 years. So I'm sorry if I'm arguing both sides of it, but that's maybe a downside of saying jump now and talk to us about necessary funding later.
I'm thinking about the fact that originally they asked for this report to be submitted to them February next year, and which suggests to me that they weren't looking to write legislation in this biennium for this. And the Chair Mahali asked to bring that forward because Chair Mahali is very interested in, I guess, writing something this year, but I'm not sure that other jurisdictional committees are on board with doing that this year. It's not clear to me what kind of consensus there is among legislators as to whether anything is going to get written up this year. Kirsten.
Yeah, so I was wondering if we would want to offer a couple options. And in my mind, a check-in would be looking at, volume of appeals, just kind of like some updated information on what that landscape looks like. So it's that external ingredient, but also inwardly looking at where we are with all of our Act 181 responsibilities and capacity, particularly with our legal staff and all of those duties. So it's kind of like an operational check-in of sorts and maybe it's more our own check-in to to kind of look at capacity. So I don't have a strong opinion on whether or not I think we should, only advocate that we think some legislation be, put in play this session or contemplate that could occur 2 years hence. I do think that we were asked in the statute to make this recommendation. And so I think that's what we should do. And I think that it should say that, as you've outlined in the report, that we take on these particular appeals, but we'll sort of would revisit some of the key information like staffing before that necessarily take effect. I don't know if we want to definitively say the 3 years. Like I'm fine with that. I think it's feasible and realistic based on what I know now. Things can change. Sorry if I'm a little like I would lean towards saying it more definitively up front, like that it be put forward this session, that we would do this on this time schedule, but we'll confirm, volume and resource issues before it takes effect. And we can say just the one tech, like that's fine too, but makes me, we just don't know exactly where we'll be. I mean, we're going to map it out. Like, here's all our tasks, providing all these things happen, looking ahead in the way that we plan to get all this work to the finish line.
Brooke, do you have the cost estimates for staffing and what page is that on?
No, actually, I didn't get that into the addendum. So hold on, let me find it. I have it.
That's okay.
It's on page 25, Janet. It's not the full breakdown that we reviewed.
Okay.
That will be an appendix that Brooke's talking about, but the two numbers of 395,000 and 126,000 are on
Is
page
on page
25.
25. Okay, got it. Costs. Okay, got it. Okay. Um,
I can share it on screen if you want to see the breakdown. Whoops.
no,
that's
I got
fine.
it. I got it. That's
Oh,
okay.
okay.
Oh, I see the other. No, that's okay. You,
Oh,
yeah,
no,
go ahead
no.
and put that up.
Let's see.
I was just looking at page 25 of the draft. So this is what we looked at initially. Okay.
Yeah, you saw it in a Word version, but this is the spreadsheet.
Yeah.
Can you see it? Is it big enough?
Yeah.
So we, it's 1 and 1 and 2 and 2 is what the two scenarios are. 1 lawyer, 1 tech, 2 lawyers, 2 techs.
Okay.
So we can mix and match however you want.
Yeah. Okay. Sorry, I just wanted to see what the breakdown was.
So either way, it's still the same upfront cost pretty much. Very little difference in the two capacities for infrastructure, but
So I think this is a good first discussion on this draft. I would like to read it closely before Monday and we continue this discussion. Can I ask anybody else that is present whether they have comments at this time on our draft appeals study report? I see no hands going up. Okay, Brooke, thank you so much. Clearly put a lot of work into that. I think it's in great shape and we will help you hone it down to the perfect, perfect piece. So,
right.
Brooke, you're looking to get this posted to the website with Maddie's help by the end of the week, right? So I'll leave, I don't have any expectations about changes necessarily. Like if it's just this draft that goes up on Friday, you're not gonna upset me at all. But if you want to make changes based on this discussion, great. And like I said, I'll send you my other comments and take them or leave them.
Yeah, give me book and page number on those sentences. I have notes, but we've talked about a lot. I can make, a few changes, but with our schedule for Thursday and Friday, I'm not gonna have a huge amount of time
Yeah,
to do
yeah.
this.
Yeah, I mean, I'd
So-
recommend just posting this now and, instead of posting multiple revisions, let's keep discussing it and, you can post a revision later. Is this Thomas or Maddie?
It's Maddie. I just wanted to
Hi, Maddie.
clarify, this draft report is posted on our website currently.
Yeah,
With the agenda.
with the agenda, but, so we were going to post it for a 10-day comment period, so. And I haven't separately sent it to the stakeholders yet, but, so we have
It's
to
also
figure it out.
posted on the appeals report page, so it's not just attached to this agenda. So it's currently on the website.
So do we need to do anything like to say, hey, there's a 10-day? Or put up like one of those banner or things?
Or
I'd be
you,
happy to talk to you about that, Brooke. We can do many things to highlight it. So happy to talk
Okay.
about that. Yeah.
Great. We'll touch base and figure that out. I'll send it
Sounds
out
good.
to all the stakeholders, but I do want to do something to let the public know.
Okay,
Great. Thanks, Maddie.
Kirsten?
well, yeah, I was just gonna say too, haven't we been doing press releases for our public meetings about draft reports? I think we did one for Wood Products. Is there, our meeting's next week on this, right, Brooke?
On what? What are you talking about? The
The
hearing?
public meeting on-
Public
Yeah,
meeting
that's
on the
Thursday.
draft is
Yeah,
next.
23rd.
Yeah, so it's
23rd.
next Thursday. So-
Yeah, it's not a problem notifying the stakeholders. They're anticipating, and Brooke is in close communication with them. The issue is the other 600,000 Vermonters who have no idea what this is. How many of them are going to attend a public hearing on it? Probably very few. But I do agree with Kirsten. Like, it seems like it makes sense to do a press release or a legal notice or I don't know, something beyond just communicating with stakeholders.
And just posting it on our website, you mean? Yeah.
Yeah,
Yeah, we can draft up a press release, get something out tomorrow.
I just did one, Brooke, earlier in the week for the tier 3 public engagement sessions. So
I'll plagiarize it, no problem.
yeah, I can send that to you as a Word document. It's just revised version of what Maddie helped me with when we did the original public engagement for tier 3 back in May.
Great. Sounds like a good plan. Sarah.
I just would like to say we do have the communications policy that just look at that while you're drafting it and I'm ready to also make a motion, but I see Maddie has her hand up, so I'll wait on my motion.
Yeah, I just wanted to say that the meeting that's scheduled for next Thursday is posted on our website under the upcoming public engagement section on the homepage. So it's been there for a while. So that information is out there.
Great.
Okay, Sarah.
Now I'll make a motion if you're ready for it.
Sure.
All right, the board needs to discuss personnel and also have a confidential attorney-client communication and move that we find that premature public knowledge of these matters would place the board at substantial disadvantage and the board enter executive session.
Thank you.
I'll
Second.
second. Oh,
Thank you, Kirsten. I think you were first. I will attribute the second to Kirsten. Okay, any discussion? All those in favor, please say aye. Aye.
Aye.
aye.
That is unanimous. So the board, it will enter executive session, and if it has anything to report back out, we will do so before coming back or before adjourning this meeting. Thank you. Hi, Maddie.
Like we're all here, Janet.
Oh, sorry. I was just looking for which page number is H on in the blue book. I had a bookmark and it fell out.
I can tell you,
Um,
it's 4460H on page 728.
Okay. So the board had a discussion in executive session with legal counsel about interpretation of enforcement of existing Act 250 permits in a Tier 1A municipality. And the board has decided that we think that the statute clearly gives enforcement authority and responsibility to the Tier 1A municipality. As for whether that is the most advisable way that this should happen in terms of Tier 1A municipalities taking on, many Act 250 permits as soon as they get that Tier 1A status and before they are transferred to by the appropriate municipal panel to the municipality. The board is less convinced that that's the best way to go, but currently that's the way the board is interpreting statute. And so that's the way we are moving forward. And we may talk as we consider legislative changes, we may discuss this at our next meeting on which we discuss legislative fixes and changes and shifts. We may add that to our list to suggest that the legislature allow that upon our conferring Tier 1A status to a municipality, that the municipality does not take on enforcement authority and responsibility for existing Act 250 permits until the permit is transferred to the municipality after a project gets an amended permit by that municipality. So we will discuss that in upcoming meetings. Kirsten.
I just offer a minor supplemental clarification that
Sure.
that we discussed that the municipal responsibility and authority for enforcement of previously issued Act 250 permits would occur within the Tier 1A area defined, for a particular municipality. So it's not
Right.
the breadth of all permits throughout an entire municipality necessarily. It's the subset of
Yes.
permits where located within the Tier 1A area.
Yes, thank you
Thank
for that
you.
clarification. And that's all that we have today. Is there any comments from anybody before we adjourn?
I'll move to adjourn.
Thank you, Alex.
Second.
Thank you, Brooke. Although all those in favor, please say aye. Aye.
Aye.
Hi.
Okay, thank you. See you tomorrow.
Thanks, Maddie.